We're ready whenever you are.
I'm Patrice Cucci, and I represent the appellant in this case, Trina Reddick, and to my left is Trina Reddick. This is a case that Reddick has brought against the University of South Florida.
Excuse me.
Yes.
You're gonna reserve 5.
I'm sorry.
That's okay. That's okay.
This was 3.
I can't keep time if I don't know.
I appreciate it. Thank you very much. Again, for reserve 3. There are 3 issues primarily in this case. One is whether or not Ms. Reddick had received proper notice to protect her rights under the Florida Civil Rights Act. Second is whether or not the trial court erred in finding that Ms. Reddick made a knowledgeable choice to go to the DOH for an administrative hearing, and that she knew that when she made that choice that that was going to be her exclusive choice. Third issue is whether Ms. Reddick's request for a Department of Administrative hearing foreclosed her right to go to court.
Can I ask you just to set the table for my questions?
Yes.
A question about procedures. Let me make sure I'm understanding correctly. There was never a determination of no violation, or was there? There wasn't, right? Because the DOH hearing never took place.
There was no determination out of the Department of Administrative Hearings.
No reasonable cause.
There was a determination out of the Florida Commission on Human Relations.
Okay, so it went to, so there was a no reasonable cause.
Correct.
Then it went, I mean, let's leave aside the procedure which we're all disagreeing on, whether it should or should not have gone. It went to DOA, because you're contending, I know that your client was misinformed when she had to do that, but it went to DOA, she withdrew or gone dismissed, that's in debate, but whatever happened, went back to the commission entered a final order of no violation.
Yes.
Okay.
Yes.
So that would, does that bring it under subsection 7? Because near the end of the USF's brief, I think they talk about interplay between 4 and 7. But I guess the question would be at that point, after they've made a plot, why aren't we governed by subsection 7?
We're not governed by subsection 7 here, because we have to look at all of the subsections in the
Subsection 7, commission determined no reasonable cause and went to DOA. And is it because DOA itself never had a recommended order saying no violation? In other words, went to DOA, came back, and there was never a full DOA hearing, and therefore, instead of being a final order of no violation based on a recommended order that said one way or the other, then because under section 7, she only has the right to go to DOA and then the
section 7 doesn't apply to this case.
Tell me why.
And that is one of the significant issues in the case. It doesn't apply because section 7, section 3, and want to remind the court, we're talking about 2008, 2019 Florida Civil Rights Act. There has been an amendment since then. That section 3 states that within 180 days of filing the complaint, the commission shall determine whether or not there's reasonable cause. Section 8 says, in the event that the commission fails to conciliate or determine whether there's reasonable cause on any complaint, then the aggrieved party may proceed under section 4. Section 4 allows the two
So my question is so you're under section 4.
Correct.
Meaning you're under section 8, which gives the aggrieved party the options of order under section 4. My question is this: if the aggrieved person does not make the subsection 4 election after 130 days, but before there is an actual determination of no reasonable cause, does that mean that the no reasonable cause determination controls, and then therefore she's under subsection 7? You're saying essentially that under subsection 8, her right to both options under subsection 4 vests.
Correct.
And there's case law in that, correct?
There is case law on that.
Yeah.
Joshua
Joshua, you said?
Joshua, out of the Florida Supreme Court.
So in other words, so it sounds to me, and USF is going to tell me differently if they disagree, that both parties are agreeing that that subsection 7 does not govern. And this is going to correct me if they disagree.
Yes, I'm not sure if they're gonna agree with that.
But so in other words, what they're saying is that, I'm making an argument they can refute, but if their argument is, or my hypothetical argument is, why does it vest? I mean, if the aggrieved person doesn't take advantage of the options in subsection 4, and then subsequent to that, I mean, they said, hey, do you want us to keep investigating? Tacitly, she said, yeah, keep investigating, and then they came out with a determination that there is not reasonable cause, which is the first sentence of subsection 7. Why doesn't subsection 7 control and define our office to know it?
Because we look to the language, Your Honor, of subsection, we look to the language of subsection 8 that states that if 180 days has passed, then you have the options of going to court or to doing the
But she
DOA.
may proceed under subsection 4. What if she doesn't?
But it also,
She waits for a determination of reasonable cause.
but Your Honor, it also states that, and this is language that is one of the big issues here. The Florida statute says the election by the aggrieved person upon filing a civil action or requesting an administrative hearing is the exclusive procedure.
She didn't make an election prior to the time that the commission decided there was no reasonable cause.
But there's nothing in the statute, Your Honor, that says that subsection 8 applies after 180 days has passed. It doesn't state that. And that was one of the issues that was recognized in the Florida Supreme Court.
Well, it subsection only applies after the days passed.
It states specifically that in the event the commission fails to conciliate or determine whether there's reasonable cause on any complaint under this section within 180 days, then they may proceed, the individual may proceed with a civil action or administrative hearing. So that's there. That's there and it stays there since 180 days has
No
passed.
tests.
It does. Does the section 8 overrule that? No, it does.
Seven.
Does 7, I'm sorry, does 7 overrule that? No, it does not. Because specifically, the other subsection says that's the exclusive procedure. And my argument, Your Honor, is that that exclusive language deals with the procedure. It doesn't deal with an election of one of those two things. It deals with the procedure. And that is actually something that was in error, I believe, in the Gore case, where the Gore case said, well, the Florida statute says once you take the election, then you're excluded. Statute doesn't say that. It doesn't say that. What it says is that the election of the to file civil action or requesting administrative hearing is the exclusive procedure. Put notice out there that subsection 7 doesn't apply. It doesn't apply because specifically 180 days in Ms. Reddick's case had passed.
So you're saying that, so that argument benefits your client in two ways. One way is that by construing that to mean that this right to make an election applies over and against any other procedure, which is to say the procedure under subsection 7. Kind of kills two birds with one stone, because the other bird that's killed is the idea that the choice cannot be revoked. In other words, elections doesn't mean election being exclusive doesn't mean it's revocable. Is that what you're saying?
It doesn't say the election. That's
Okay, so what happens if the election is not irrevocable? How far into the DOE proceedings can a aggrieved person go and still say, you know what, this isn't going my way. I want a civil action.
I would say under the, which I also agreed, under the issue of election of remedies, that if DOA had made
Anytime, in other words, until there is a actual final order adopting the recommendation or making exceptions and affording relief, a remedy, she can say, you know what, I don't like this, it's not going the way I want to go to civil. I'm going to file civil action.
I state, Your Honor, because the statutes specifically state that that it's an exclusive procedure. It doesn't state what the Gore report says. It stated is that once you make an election, then you can't go back. Now, in Ms. Reddick's case, we don't have to analyze about whether it's halfway through trial. One of the things that was discussed in the Gore case was that the Gore party had not engaged in meaningful
You have
situations.
to decide, because unless you can draw a line that's supported by the language in the statute, you have to stick with your position, and you have to address the reductio ad absurdum argument, which is that you can come all the way to the point where the hearing is completed. You can come all the way to the point where the DOA judge makes a recommended order, sends it to the agency, and the agency files exceptions, and then the DOA judge, and at that point, before a final order of the agency, the agreed person can say, I want a civil action. Don't you have to concede
if
that?
that's not acceptable, I would say, Your Honor, then the statute should be clarified
Okay.
to
Isn't
identify.
there another reading though of election? The election by the agreed person following a civil action is the exclusive procedure. In other words, under subsection 4A and B, it provides two procedures between which the agreed person is to make an election. And then that election, what she elects is the exclusive procedure.
That simply
It says exclusive procedure available to the agreed person.
exclusive procedure, not the exclusive election. And the Gore court went out of
What's
its
the
way
difference?
and added words to the
What's the
statute.
difference
I'm
between,
sorry.
well, you've made an issue of that in your brief, the difference between procedure and election. It seems like a distinction without a difference. Can you help me understand the difference?
The two options together is one procedure. The availability of those two options to a claimant is a procedure. And I want to cite to the court the Maggio case. That case was cited by the Hill Court. The Hill Court was the Middle District Court case that cited Gore and cited Gore's the state is erroneous language. Gore added language and said, once an election is made, the exclusive procedure is available. Well, Hill cited Gore, but they also cited Maggio. And Maggio is a Florida Supreme Court case in 2005. And in Maggio, the court stated they were citing 760.114. And Maggio's Florida Supreme Court said the two procedures set forth in section 4 are the exclusive procedures available to the claimant pursuant to the act. And that's what I'm stating, Your Honors. Those two procedures.
If that's what were to reach the conclusion that section means that, wouldn't the section say the procedure in subsection 4 is the exclusive procedure? And it says the election, the choice is the exclusive procedure available. The choice among two procedures is the exclusive procedure available to the agreed person.
It doesn't say that language, Your Honor. I don't.
It says election. What's the difference between choice and election?
It states
I
that.
mean, if it said choice, you'd be making the same argument, right? You'd say, well, the choice means subsection 4 in totality. It means this is the procedure. The choice is the procedure, not. So you have you're saying the choice itself is the procedure, the election. Yet the election is among two procedures. Isn't the more intuitive way to read it that which procedure is elected is now the exclusive procedure?
I just have to disagree, Your Honor. I don't believe it can be read that way. The legislature could have certainly said that under the subsection, the exclusive election available. It doesn't say that. It says exclusive procedure. And that.
But isn't the election between two procedures?
No.
Civil
It's
action
one
and administrative
procedure.
procedure are not two separate
One
procedures.
procedure that allows two options to the individual.
Two options of what?
Two options of how they want to go
Procedures.
forward. No, it's one procedure which has the two options in it. And that procedure is the exclusive procedure. Why do we need to have that exclusive language in there at all? Because as you pointed out, Your Honor, we have subsection 7, which says you don't get to go to court. But subsection 7 doesn't apply if 180 days has passed. Then you have the circumstance that you don't have just the one, which is to go to the DOAH. You have two as part of the exclusive procedure.
Isn't there another way to form that argument for, I've just paused this, and if I put it in brief, I apologize. Even if I were to accept for the sake of discussion and USF's argument that the election, that the exclusive procedure refers to which procedure under subsection 4A or B was chosen. Isn't there still an argument in your favor that they can't get to subsection 7 because it vests, the right to choose vests? In other words, and so they never got to subsection 7 because that was foreclosed to them, because we're writing under subsection 8, which gives them 180 days, and after which they can't make. So my question, if that's the case, again, you might have raised this argument.
And you're well into your rebuttal time, just so you know. Okay.
Well, maybe I'll ask that of USF, but
Well, no, I'd like to respond to it, Your Honor. I think that that's another issue that has to do with the notice issue, which is, it's a requirement in the statute, and under the Joshua case for due process to give notice and an opportunity, but notice is one of the requirements. In March of 2019, notice was given to Ms. Reddick that she could go beyond those two options. It said 180 days has passed, you can do one of 4 things.
that just sounds like they were giving themselves another option.
And that's fine. And then it states, and the USF has argued that because it said it's 1, 2, 3, or 4, that then it means they're exclusive. Well, if you look later in that same letter, it says if you choose for us to go forward, you can change your mind on that.
Yeah, but that just says if you choose for us to go forward. Doesn't they didn't concede that if you choose one of A and B, you can go to choose A and go to B. But
And they didn't notify her of that either.
okay.
And then the real issue, Your Honor, is in June of 2019, the Florida Commission on Human Relations sent another letter to Ms. Reddick. And in that letter, that's when they said, here's your only choice. Your only choice is you can go to the DOAH. And it's based on section 7 of the statute, which says if you don't go to DOAH within the 35 days, the claim is barred. That letter should have never been sent because it didn't apply, because the 180 days had passed and that required the other section to be applicable. I'm out of time, Your Honor. Do you have any?
You have 3 minutes left for rebuttal.
Right, I would
Okay.
like to save them.
Okay, thank you.
May it please the court, Jason Hill for the University of South Florida Board of Trustees. I'd like to actually jump right into Judge Atkinson's remarks, if I may. There's not necessarily a disagreement here that subsection 4 could have applied, and in fact may have applied. When we look at the Woodham decision from the Florida Supreme Court, it states that after that 180 days passes, the aggrieved individual maintains that right to still proceed under subsection 4 if they would like to. There's no rule, statute, or case law that says that the FCHR is prohibited from then completing its investigation and issuing a no-cause determination. It's certainly not in the statute itself, and it's certainly
At that point, is her sole remedy subsection 7?
at which point you're
Is that your argument? And I'm confused.
No,
about
no,
the argument.
Your Honor, I respect to say no.
Okay.
Much like Morton's Fork, under either scenario, it leads to the same conclusion. In fact, Judge Antune addressed this in
Morton's Fork?
Morton's Fork, Your Honor.
Is that like Boogie Bear, if you see a fork in the road, take it?
Somewhat. Morton was a tax collector in English Times, and he said, well, clearly, if you're wealthy, you must be able to pay your taxes. Clearly, if you're poor and you're not spending, it must mean you saved your money and you can pay your taxes as well. So under either conclusion, it would lead to the same inevitable outcome. Here, whether she's proceeding under subsection 4 or subsection 7, her rights would have been limited to the path that she chose. And if we look to the Hill decision that was issued by Judge Antune of the Middle District of Florida, it is, by all accounts, the most on-point decision we have that reached the same conclusion that our trial judge reached here, reached the same conclusion the ALJ reached here. It also reached the same conclusion that Judge Conway reached in the Velez case, finding that election to be exclusive.
So in other words, so let me ask you this. So your point is, And as Judge Tun's point this as well, or is this a necessary consequence of the point that you say you and Judge Antune share, which is that after the 180 days, it's essentially a race between the aggrieved person and USF as to who will, she has from that point until the commission, not USF, the commission, until the commission makes a determination of no reasonable cause for her to avail herself of the subsection 4 remedy. And if she doesn't do it in time, subsection 7 then controls.
No, Your Honor, I would not agree with that. The Woodard decision says that even if a no cause determination comes out after 180 days, the aggrieved individual may still elect to proceed under subsection 4.
Okay.
So once that 180 days passes, that claimant may continue to proceed under subsection 4 if the claimant.
And that's why I might have correctly understood your opinion as not actually making the argument that we're under subsection 7. The remain under subsection 4, and your argument is that she did make the election, and you read the statute differently, the hanging paragraph, which I thought was an interesting characterization. The hanging paragraph to be not that subsection 4 is the exclusive remedy over subsection 7, but rather the choice made pursuant to subsection or by the aggrieved party is then the only procedure available to it.
Correct, Your Honor. Consistent with the case law that has come before us, Judge Antune in the Hill decision, Judge Conway in the Velez decision. Once the election is made by the aggrieved individual, that becomes, quote, the exclusive procedure. I see no reading of the statute or the case law that we provided that creates this bifurcation of procedures and somehow a conflation of multiple procedures into one election. It talks about making an election.
I don't mean to interrupt you, but I want to make this point. Her position is she made that election because she was told that was the only choice she had.
That is what she says, based on her declaration. Correct.
Well, the letter seems to say that.
Yes, Your Honor. And if we look at that analysis, we have to look at the due process analysis behind it. Because the claimant's knowledge itself is immaterial. It's not built into the statute. The statute talks about making an election. There's no requirement in the statute that says it has to be a knowing election. Plaintiff's insistence this was an error because it was a knowledgeable
What's
choice.
our argument to make?
What's that, Your Honor?
The issue of a knowing election. I mean, so you're suggesting that she can be misled?
No, Your Honor. I'm insisting that we look at due process and evaluate whether it should proper notice, but not that the statute itself requires it to be a knowing election. What she thought in her mind in terms of making the election is regards to her subjective belief about what election to make. Whether she received a notice would be a due process
The
analysis.
position is that your client misled her into making that election.
Well, to put a fine point on her position is that the FCHR misled her, not, I represent the University of South Florida.
Would you agree that they did? I mean, if I read that letter, which I'm going to forgive myself for my own confusion, hypothetically, I forgive myself, but because I read that letter, I read that letter and it sounds like, oh, this is subsection 7 letter.
I would not agree with that conclusion. I would agree that it is a subsection letter and that identifies the plaintiff's rights under subsection 7 if she decided to proceed under subsection 7.
What would it be? We're not under subsection 7.
She has the ability to choose which route, because if you look at, Your Honor,
Okay, let's look at that.
Yeah.
So subsection 7 says, let's see here. Okay, so well, that raises the question. What is the point? Okay, so your position is 180 days is blown, and anytime between the 180 days and the time of a determination, reasonable cause determination, she has A and B. And then when there is a reasonable cause determination, she has A and B. But if the letter said you only have, sorry, I forget what you said, you only have a DOE hearing, then yeah, of course, that's one way to characterize it. Oh, that's not a subsection 7 letter. That's just saying if you choose B, then you've essentially chosen 7 because we made a not reasonable cause determination, and therefore all you have. But the read the letter, it sounds like you only have B now.
those are the options available under subsection 7 when there is a no cause determination. When we look at the Woodard case,
Okay.
I'm saying she has the ability, it is permissive whether she chooses to proceed under subsection 8 to then go to subsection 4, and sorry for all the subsections, but It is permissive under subsection 8 to say an aggrieved person may proceed under subsection 4 if the commission determined that there was reasonable cause, but if they also fail to determine whether it's.
Wait a minute, but that, so may proceed under section 4 says you get two options. But they could proceed under 7, which is one of the options under
So
subsection.
if proceeding under subsection 7, as Judge Antoon explained, then you only have the FCHR proceeding.
No, but let me, to say what you just said, sounds a little bit, I don't mean this as criticism, but it's like sophistry. To say, well, if you choose B, you're under subsection 7. Well, of course, I mean, those are the procedures for a DOA proceeding after a non-reasonable cause determination. But it just so happens that, I mean, it's sophistry to say, well, you're obviously choosing 7. No, you're choosing 4B. You're choosing 4B, and you, and not you, but the commission made her, led her to believe, their argument is, they led her to believe that she only had B. Or alternatively, as you said, as I've been saying, you only had 7. Which that, and if either one, which is a misstatement of law, right?
I would say that the no cause determination explained her rights under subsection 7, and she still had the ability to go back to the 180-day letter. Nothing displaced that letter. Nothing said that she could no longer go to court or that the 180-day letter was otherwise abridged. And when looking at it from the due process requirements, I contend, and USF submits, it was proper notice to her. Notice does not require strict compliance.
The no, not reasonable cause determination. Don't you think it's, what if I were to hypothesize? Maybe it's facts, not evidence, but the fact finder could hypothesize that that was just a mistake, that was someone in the FCHR thinking, oh, well, this is no reasonable cause, this is what we normally send out, we just tell them their only option, which is a DOA hearing, it's a, you know, it's a point of entry, so to speak, in the admin law world. She got her point of entry, and her point of entry is DOA, because we came up with this sort of.
I would say,
Yeah, I know you want to answer this question, but I told them the letter,
yes,
and we keep talking about this, they're only given one choice. The actual language, the top of paragraph 2 is complainant may request an administrative hearing with the Division of Administrative Hearings by filing a petition for relief within 35 days of the date the determination was signed by the executive director. That's the language we're talking about. It doesn't say this is your only option. It presumes, I guess, that's your only option.
it says complainant may request an administrative hearing. These are permissive options.
Let me ask you this, if Judge Morris having read it, read that, maybe think something. If you're saying that she still had options under 4, then why was the 35-day time limit applicable at all?
The 35-day time limit applies if she's proceeding under subsection 7.
We're arguing that she wasn't proceeding under subsection 7.
I'm saying if she was proceeding under subsection 7, it was her only course. I'm saying if she's proceeding under subsection 4, she's still confined to the proceeding that she elected because her election becomes the exclusive.
Which is you have to make that election in 35 days.
No,
Then why was it in the letter?
the letter refers to it under subsection 7 and it explains what the
But if she's trying to pick 4B, she has more than 35 days, correct?
If she trying to type.
Right, subsection 4 and
Subsection
4B,
right.
that election is not confined to 35 days, right? Because because this commission already blew its 180 deadline, and you've, correct me if I'm wrong, conceded that right vests after the 180 days. So the time limit included in the letter was a mistake, correct?
No, Your Honor, I would not say it's a mistake. As a starting point, I would certainly say there is not a disagreement that she maintained her rights under subsection 4, because that is clear from the Woodland
Then why
decision.
did she only have 35 days?
Because that is how it's handled under a section 7 on a no cause determination. Now the FCHR will cancel.
So this goes to maybe subsection 8 too. You're saying may proceed under subsection 4. So you're saying essentially that she decided not to proceed under subsection 4 and instead proceed under subsection 7. But that's not true.
Not necessarily.
If she's under subsection 4, 4B doesn't have a 35-day time limit.
Right, PR, but if she is proceeding under subsection 4, she made her election to go to DOA, and that election becomes the exclusive procedure. So
I've already made the election, so why does the 35-day time period exist?
At this point,
At all.
at this point, she's not made the election.
At what point?
When the no cause determination was issued.
Yeah, no cause
Right.
determination is issued,
And so,
but that's irrelevant. She could have made the election before that or after. After 100 days, it's her option. Would you agree or not? It's her option at any time. before she can sit on her rights. I don't know how long, that's a hypothetical question of the day, she can sit on her rights, the no cause determination, really is irrelevant. I mean, obviously, she probably wouldn't want to go a hearing but she could still want to go a hearing, she said, you know what? I want the DOA to decide my rights, even though your recommendation there is reasonable cause, I don't want to go to court. That's your option, isn't it?
I would disagree, it's an indefinite choice perhaps, but it's hypothetical. I guess not present here. But yes, she maintains the rights under subsection 4, and here, whether she's proceeding under section 7, subsection 7, or subsection 4, she made that election under subsection 4. It still confines her to that choice that she made of the DOA proceedings, which she.
That's a subsection 4 hanging paragraph
Correct.
question, not a subsection 7 35 days question, which is what I'm asking.
Okay.
Why does the letter include 35 days? If it wasn't misstating to the aggrieved person that subsection 7 controlled and their only option was a 35-day choice of whether to go to DOA or whether to let her claim be barred.
Because under subsection 7, there is the 35-day limit at that point before the SHR will close out its claim consistent with the statutory guidance.
Would that be an appealable issue? If they close out their claim, if they extinguished her right, which you said is not indefinite but extends past 180 days, wouldn't that be appealable? Would they be permitted to close out the file after 35 days? If commission blew the 180-day deadline, are they permitted set 35 days after a untimely, no reasonable cause determination to close the file and dismiss your case?
Yes, I would argue at that point, once they reissue a no cause determination, if the individual does not elect or exercise their permissive option to proceed under subsection 4, the 35 days would apply, or else it would be an indefinite count or an indefinite timeline.
I mean, would you agree that this June 19th notice of determination of no reasonable cause is certainly less than complete?
I would argue that it contains the requirements under subsection 7 of what happens when a no cause determination is found. It did not unwind or displace anything from the 180-day notice. And under due process cases, cited in our brief, Dawson, citizen, strict compliance with the notice requirements is not required. It's a reasonableness standard. We've seen instances where the Supreme Court
Misinforming be a reasonable notice?
I would argue that this, to the extent you're suggesting misinformation, I would say it's not misinformation, but hypothetically.
You just said that it provided an explanation, a notice of the procedures under subsection 7. So I personally would like to know whether you believe subsection 7 was applicable. It sounds like you're saying it was, but that means by that rationale, you're concluding that under subsection 8, she had decided not to exercise her 4B rights, but instead to exercise her subsection 7 rights, which afford her much less flexibility.
Our argument is, I guess, irrespective of which right she's exercising, she's still in the DOA proceeding. If she's exercising her 4B right,
She's in a commission proceeding in which she gets to elect whether to go to DOA.
right, and she elected to go to DOA, and whether she
Under
did that,
4B.
right, so correct. And once she made that election,
At that
it
point,
became her
35
exclusive
days is
election.
irrelevant because she's already made the election.
Once she makes the election, the 35 days can become relevant because she.
Why is it relevant? She's already made the election.
I'm sorry.
Why is the 35 days? In other words, we're getting a chicken and the egg problem. You said when she decided what I say is 4B, you said, well, the 35 days is relevant. It's irrelevant because she's already made the choice, so you don't need a deadline to make the choice you've already had. We've already made.
The deadline will talk about when the SHR will close its file and issue it, but whether she exercises subsection 4 is permissive. That's up to her. She does not necessarily have to exercise any rights under subsection 4. That's because subsection 8, which kicks her up to subsection 4, is permissive. And once she exercises those rights, that's what we've been arguing, that becomes the exclusive procedure for her to continue with DOA once she elects to proceed with DOA. She can't then pull out of DOA, which is what Judge Hill concluded under similar circumstances as we had Judge Antune decided in the Hill decision with what we have here with the 180-day notice, the no cost finding after the 180 days, because the election was made. So it's the same outcome that we would argue for here is when she made that election, even if it is under section 4B, she made that election to go into DOA proceedings, and that was her exclusive election. And consistent with, again, the case we've talked about, she cannot then undo that election. Here she withdrew from DOA on the eve of the hearing. She could have had the opportunity to be heard. She could have had the full relief she wanted. She'd been in the DOA proceedings for months. And with the advice of counsel, she withdrew 1 week before her administrative hearing.
So if we go, decide what Judge Morris was focusing on, even if we decide that your construction of subsection 4 hanging paragraph is correct, meaning the election, which means the choice of procedure among A and B is now the exclusive procedure. Could we not still rule in favor of the aggrieved person because she made that election based on inadequate notice?
I would argue the notice was adequate and consistent.
If we decide that the notice is it was inadequate or misinformed, is there some other argument that you have to against us ruling in favor of the aggrieved person at that point?
It would be a due process argument, Your Honor. So that would be a question of, did she receive proper notice? And that opportunity to be heard, I think we can set aside the opportunity to be heard. It would essentially be a question of, did she receive proper notice under the case law? And at that point, if you decided that she did not receive proper notice, then it would be a challenge to continue that approach. We of course contend that she did receive proper notice for the cases cited here in the plain language of the statute. But yes, our argument is premised on application of the statute, specifically section 4B, emphasizing the exclusive procedure that she initiated and the election that she made to go into that procedure with DOA, which would have afforded her a resolution, right, wrong, or otherwise she would have received a resolution had she not withdrawn 1 week before the administrative hearing, after previously being warned of the consequences of withdrawing and informing.
Now, did that cure? Let's say that we determined that that the letter misinformed her. See, but the problem is with the argument of that curing it. In other words, the subsequent is that that subsequent advice is premised on the supposition that she made an informed choice to go to 4B. So yes, so it's hard. It may be hard, or you can tell me why I'm correct. It's hard to argue that it cured the misinformation. It's for the sake of discussion. We're conceding that it's misinformation in the letter.
No, Your Honor,
And you're out of time, just so you know, so just wrap it up.
okay, thank you, Your Honor. No, you are correct. I'm not arguing that the ALJ's later statements would have cured any prior information, because yes, intellectually, I could never say that to you. But the argument we're saying is the ALJ advised of the consequences once in DOA to the extent she had persisting confusion about what would happen. The ALJ advised her to legal counsel. She also did get legal counsel when she withdrew from DOA. She was represented by counsel, but it's not our position that anything that the ALJ advised Ms. Redick would have impacted any prior communications from the SHR. But in conclusion, we emphasize that the plain language of the statute that discusses once an election is made, it is the exclusive procedure. That election was made here. There's no knowledge requirement in the statute. It's faced. We believe that should be the exclusive procedure, which was DOA.
You have 3 minutes.
There's a reference to Ms. Redick choosing to go to subsection 7. I frankly don't remember who threw out that word choose. A claimant doesn't get to choose to go to subsection 7 if 180 days has passed. Because once 180 days has passed, subsection 4 says you use subsection 8.
So let me ask you this: how long can a aggrieved party sit on her rights under subsection 4? In other words, once the commission blows 180 days, they can come out with a reasonable cause, no reasonable cause, termination, and then are they required to just wait
Well,
indefinitely
unfortunately,
for the aggrieved person to make an election between 4A and 4B?
unfortunately, the statute is silent on it. Statutes are silent on that. Now, as far as choosing to go to court, of course, we have the statutes of limitations. And that would kick in for the selection.
So, but some paper from your position would be, she retains the right under subsection 4 to choose ARB. Notwithstanding that, no reasonable cause of termination is mentioned.
Correct. That's it. It's 7 does not apply because 180 days passed. The other is whether there was a reasoned election, and looking at the letter that your honor has in front of you, it says that you talked about the 35 days, but the letter also says that if you do not file a petition within 35 days, the commission will dismiss the complaint. And the language of the 35 days is contained in subsection 7. And even though it does not apply, it then, if it's investigated by Ms. Reddick or her attorney, that subsection 7 goes on to say if the aggrieved person does not request administrative hearing, the claim will be barred. That's what the statute says. So Ms. Reddick did she have a reasoned election? Well, what she did is she did what's similar to the Gore party did, which is she filed to protect her rights for a DOAH. But every filing that she made with the DOAH, she stated, I want to go to court. I wanted to go to court. And then ultimately, that's what she decided to do. I want to remind the court that the Hill case, which USF relies on, totally relied on the board decision, which we feel is an incorrect decision, is contrary to the Maggio decision. The Velez case really has no facts to substantiate why summary judgment was entered. And the court said there was no prima facie case, so we don't even have to look at that other issue. Your Honor's order granting summary judgment should be reversed and the case should be remanded to proceed accordingly. Thank you.
Timing is excellent. You nailed it right at three.
Thank you.
This is a very interesting case, and I have to tell you, I learned a lot from your oral arguments there. I don't always say that. I mean, there's a lot of things I was confused about. You're helping a lot with, so I appreciate it. Have a good day.
Thank you, Your Honor.
Oh, yeah, we're gonna take a